Welcome to the Mary Ewing Law Show.
Welcome back to the Mary Ewing Law Show. Mary is a veteran Colorado attorney with more than 40 years of experience helping clients through personal injury, workman's compensation, and family law cases. Known for her steady, practical guidance, she helps people make sense of complicated legal processes during some of the most emotional times in their lives. I'm Leann Lyon, and today we are breaking down what actually happens in divorce mediation and court hearings, so you know what to expect, how to prepare, and what not to worry about. Hello, Mary.
Hi there. How are you?
So good. Thank you. Mary, what is mediation and why does the court require it in most Colorado divorces?
Mediation is, you might think of it as a settlement conference. It's an opportunity for the two sides to speak with an independent person named the mediator to express what's in dispute, what's in agreement, and try and reach some form of agreement. Courts require it because it can be very successful. But unless parties have literally some pots and pans to divide, I think they need attorney representation. Why? Because the mediator is not allowed to give either party legal advice. The mediator's job is to get the parties to come to an agreement. So trying to get to come to an agreement might not be in the best interest of a particular client. So it is important, particularly in divorce mediation, because there's so many ins and outs of it. You might have to give on one place in order to reach an agreement on another. So that could be important. Mediation could be, well, it generally is required, but it doesn't mean you have to come to a settlement. You have to participate in a good faith effort to mediate.
So who is usually in the room during mediation, and how formal is the setting compared to, say, being in a courtroom?
Sure. Most of the time, the parties are in separate rooms with their counsel or without counsel. And the mediator does what you might think of as shuttle diplomacy. Is it formal? No. It's often it could be in the mediator's office. It could be in one of the attorney's office. Since COVID, many mediations are done virtually through Zoom, but still with separate rooms, so to speak.
So how should someone prepare before they walk into a mediation? In other words, what kind of documents or information is helpful to have ready?
Well, I think, in divorce, there's two major areas of controversy. There's the financial arrangement, and there's the arrangement regarding the children. Regarding the financial arrangements, I think it's important to have some kind of spreadsheet that shows what various assets are and how, if there's an agreement on any division of assets, something that tells you, we've agreed to this, we've agreed to that. But what you don't have to do, what you're seeking to do, is an equitable division. Equitable means fairly. Most often in financial arrangements, it means equally or close to it. But it doesn't mean each individual asset has to be divided equally. One might say, well, I want the house, it's got X equity in it, but I'll give up X equity in the 401k plan that I have, so that you reach some kind of equitable, meaning fair, meaning 50% division. With the children, of course, it's not a simple formula. And you need to have well in mind that the goal is what's in the children's best interest, not what's in either party's interest. Child support is handled by a formula based on the number of overnights and the party's respective income. If there's a dispute over income, then it's important to take into the mediation what evidence you have to support your position of what the other party's income actually is. With regard to the parenting time, the number of overnights, if there was an evaluation by a child and family investigator or an evaluator, take that in. You may agree with it, you might not agree with it. If you don't agree with it, be prepared to explain why you don't agree with that and, well, what it is you don't agree and why you don't agree with it. So that's what I would recommend.
And in that case, what is the mediator's role and how is it different from what you do as an attorney?
Well, the mediator's role is simple. Get the parties to reach an agreement. That's their role. Not to give legal advice. They're usually very pleasant. They try to get the parties to relax. Each mediator handles mediations a little bit differently. Some mediators will express their opinions on what agreement should be reached. Others don't at all. But the job of the attorney is to give the legal advice, to make representations to the client on what they should do. Of course, it's always the client's final say, but it's important that the client understands what the attorney's recommendation is and why. And it's important for the attorney to explain in a compassionate, understandable way with the client on what their opinion is or what's the prevailing law and how does it apply to their case.
And in that case, how do you help clients stay calm and yet stand their ground when they disagree with something that comes out of mediation?
It can be a very emotional time in their lives, and they may not be able to stay calm. They may be very upset. What they're dealing with is how their children are going to live the rest of their lives with their parents, what the children are going to be able to do in terms of activities, and for the spouse individually, it's how much money they're going to have and what availability do they need to have set aside in their lives to spend with their children. So I start with a Churchill quote, "When you're going through hell, keep going." I think that's a great quote in divorce cases. So they don't have to agree on something in mediation that they're not comfortable with. They could not agree. They could say, "I'm not doing that." Perfectly in their rights.
So if mediation doesn't solve everything, what happens next? Does the case automatically go to a hearing or are there other steps in between?
In all cases, I would say, I find it helpful to try and check off, so to speak, what the parties can agree with, to narrow the issues so that judges usually say to clients before them that the clients can work out a better agreement than the judge who doesn't know them and just makes a ruling. And I think that's really true. Some attorneys counsel their clients, if you can't agree on everything, don't agree, period. I think that's bad advice. It saves a lot of attorney time, which results in a cost savings to the client. If you can narrow the issues before you go to hearing. With regard to the hearing, there may be some discovery things that weren't quite finished, weren't quite ripe, like if there's a dispute over what's going to happen with the house, then maybe an appraiser still needs to be hired, or maybe they reached a tentative agreement on selling the house, but they haven't reached an agreement on who the realtor's going to be and who, whether they're going to follow the realtor's advice on the pricing, things like that. So those can be things left hanging after an unsuccessful mediation to try and that are still hanging out there before the actual hearing. Generally speaking, after the mediation, the court will set the matter for what's called a permanent orders, which is the divorce trial, so to speak.
Okay, well then let's talk about hearings. What does a divorce hearing look like?
Well, it's in a courtroom. There's a judge presiding over the hearing. The parties with their counsel sit on one side of the courtroom. Other side sits on the other with their counsel. There's no jury. There is some form of a recording of what's happening. The whoever was the petitioner in the case generally goes first through the presentation of their evidence, and exhibits are received into evidence. The attorney would have made a preliminary statement before calling witnesses, but the party will generally be the first person to be called. You may or may not call the opposing counsel. You may call any expert witnesses like the appraiser or the child and family investigator, or if they're friends, coworkers, employers that have some relevance to the proceeding. And then the other side puts on their evidence through their testimony and exhibits. Most of the time, judges take the case on what's called advisement. In other words, they don't rule from the bench. They say, I need some time to think about this. I'll either enter a written ruling, or they'll set another hearing briefly for the judge to make the ruling orally.
And what should the parties expect from the judge? Do they ask questions, or are they mostly there to just listen?
Well, like with all walks of life and all positions, there are good judges and bad judges. But I like to think that all judges are doing the best that they can to be fair, to listen to the evidence, to rule promptly on objections, and to try to ultimately reach a decision that's in the best interest of the parties and the best interest of the children. And, I've had a couple of times when my client's position and the other client's position wasn't what the judge found. They came up with a different solution that was actually much better than either attorney had proposed. And that's within their rights to do that. The judge generally just listens to the testimony, but after the witness finishes testimony, the judge may ask some questions of the client or the witness, whomever is testifying. They're certainly within their rights. And that can be important at least I think it's important. It tells me, what's the judge thinking? What is the judge worried about? What does the judge want more information about? And usually you have an opportunity, well, always you have an opportunity after the judge asks the questions to inquire further. Now, you may want to do that, you may not. And most of the time today, cases are set for a specific amount of time, and each side gets a specific amount of that time, and the judge is keeping track of it. So you don't have as much time as you might like. So you do have to keep the timing close at hand.
Excellent point. Well, I know you have sat besides hundreds of clients in these situations. What is one thing that you wish everyone knew before walking into a hearing or mediation?
I suppose expect the unexpected. Um, I take a notepad and a pen for my client during a hearing, and I caution them if they want to tell me something, either ask for a break or write it down. I can't listen to what the judge is saying or what the other attorney or the witness is saying if I'm also trying to listen to my client. I do want to know what my client feels I need to know. That's important. But you have to be cognizant that you can't separate your ears. You can't listen to one person versus the other. So that's what I think clients need to expect. They should expect that the judge may ask them questions and be prepared for that, not get all, but it's okay to get nervous. It's okay to cry because this is an important emotional time. And I don't think judges look necessarily one way or the other because that happens.
Well, I appreciate that. And I've never heard anybody say that before. I like that about you can't split your ears. That's excellent. Thank you. So finally, as we wrap up today's episode, and this is for somebody listening who feels just anxious about facing their spouse or appearing in court, that could be very scary. What would you tell them to help ease that fear?
It's a very natural reaction. The divorce may be very acrimonious. They sometimes spouses are still in love with their spouse and they don't want the divorce, so it's emotionally difficult in that way. Or there's anger because of what's been going on in the divorce. I tell them my job is to take care of them in the courtroom, and I will do that. They don't have to talk to their spouse. They don't even have to look at him or her. They can just pay attention to the judge and listen to what's happening. So that I think that helps for them to know that they're not going to have to interact with their spouse, and it calms them down.
Well, that is it for today's episode of the Mary Ewing Law Show. If you are going through a divorce in Colorado and want clear, steady guidance about what to expect, visit maryewinglaw.com or call 303-886-5400. Thank you for listening, and remember to like, subscribe, and share this episode with someone who might need it. Thank you, Mary.
My pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.